Hello, good evening, everyone. A very warm welcome to today's virtual panel discussion hosted by Mediate Guru on the Mediation Inside Out, Adoption, Barrier, and Breakthroughs in the Corporate World. My name is Kanika Saxena, and we are thrilled to have you join us from wherever you are tuning in. In today's rapidly evolving business landscape, conflict is inevitable, but how corporations manage the conflict is changing. We often hear about mediation as an efficient, cost effective alternative to traditional litigation or arbitration. But the question we're tackling today is mediation truly embedding itself within corporate structures, or is it still facing an uphill battle? The core belief driving this session, and much indeed of Mediate Guru's work, is that mediation can only become truly mainstream when corporate houses actively embrace it, preferring it over the dispute resolution methods. Today's discussion aims to be significant step on the path, the goal moving beyond theory to explore the practical reality. We live in an era of complex global business operations, integrate contracts, and diverse workforces. Efficient conflict management is just a nice to have, it's a strategic imperative. It, this makes understanding the real world adoption rate, the persistent barriers, and the innovative breakthroughs in the corporate mediation absolutely crucial. Over the next 60 to 90 minutes, we'll be diving deep. We'll explore, firstly, how widely is mediation actually being used across different corporate sectors and company sizes? Secondly, what are the real roadblocks? Thirdly, where is it working? And most importantly, how can mediation move from being just a reactive tool to a proactive strategic asset for business? Finally, we'll move ahead at the future trends, shaping mediation's role in corporate conflict management. This discussion is vital for anyone involved in corporate legal strategies, human resources, business leadership, or the area field itself. From in house counsel and external practitioners to HR professions, compliance officers, mediators, academicians, and the law students who will shape the future. To guide us through this crucial conversation, we have an exceptional moderator. Please welcome Swastika Chakravarti, Principal Associate at the renowned law firm Khaitan and Company. Swastika brings extensive experience in dispute resolution and will expertly navigate towards today's complex themes. And Swastika will be leading a truly stellar panel of experts, each bringing invaluable insights from the host frontlines or corporate legal practices in India. First, we have Mehak Oberoi, the legal head from Hydro in the APAC region at the GE Vernova. Mehak brings a critical in-house perspective from a major global industrial player. Joining her is Ojaswita Srivastav, Journal Counsel for Securitized AMEA, offering insights into risk management and legal strategy across the diverse AMEA region from a leading security service company. We also welcome Prashant Singh, Senior Legal Manager at Axis Max Life Insurance Company Limited, who will share experiences from the dynamic and highly regulated insurance sector. And rounding out our panel is Shruti Kanijov, partner at Shadul Amachandas Mangaldas and Company, one of the India's top law firms. Shruti provides the vital perspective of external counsel advising corporations on dispute resolution strategies. We are incredibly fortunate to have such a distinguished group with diverse experience ready to share their knowledge. We encourage you, our audience, to participate actively Please use the chat box function to submit your questions throughout the session. We'll aim to address as many as possible towards the end. So let's start our journey to understand mediation inside out. Swastika, thank you for leading us today. The stage is yours.
Hi. Thanks, Kanika. Thanks for the wonderful introduction for me and the rest of the panel. And yeah, good evening, all of you. And thank you so much for joining us on this Sunday evening. Um, so without much, much else to distract us, let's directly, jump into the topic for today. And as Kanika has introduced it, we're talking about mediation, its adoption, barriers, and breakthrough in the corporate world. And from the introduction of the panelists, you already know we have a stellar panel and so many years of experience in house as well as in law firms, and we'll be hearing all their thoughts on each of these aspects of mediation. So without much further ado, let's quickly start with our panel discussion. Ojaswita, coming to you, um, we would like to know, why do you think mediation matters in today's world? And in your experience, could you let all of us know how mediation has proved to be a tool for conflict resolution in corporate disputes?
Thank you, Swastika. Thank you so much for that question. I think it's about time that we start discussing mediation. We have been talking about arbitration for long, but mediation is an equally strong tool, and in some cases, probably a stronger tool for dispute resolution as compared to arbitration, when the matters can be resolved probably a lot faster. When it comes to business, when it comes to doing any kind of commercial work, I think time is money. And where we really suffer in terms of dispute resolution is how it's time consuming. Whether you go into litigation, whether you go into arbitration, it usually takes about a year plus. Whereas when it comes to business, you want the problem to be solved as soon as possible so that you can get on with your work, right? So I think mediation is an extremely powerful tool that way. I think time is definitely money, and mediation is the solution when it comes to dispute resolution. There are certain kinds of disputes only that can be addressed through mediation, and I think it makes a lot of sense to look at, seriously consider mediation as a dispute resolution tool. I think what we had been missing so far is a strong infrastructure for really enforcing and going for mediation. There was also, to a large extent, a lot of lack of public awareness for mediation as a tool for dispute resolution. And even the procedures weren't very clear. The lawyers weren't very clear. We weren't really promoting it as such. But I think now with the law in place, now with us having the good case study with the Lodha brothers, and us seeing that there is actually a strong case for mediation, I think it's about time that we start looking at it as a serious dispute resolution mechanism.
Thanks, Ojaswita. That is actually an interesting perspective. And yes, the recent legislative changes and the act coming in have certainly clarified, the enforcement and other aspects to a great degree. Uh, but let's talk about practical insight. So, Mehak, we really want you to shed light on, mediation versus litigation. Exactly uh, how do you decide on which disputes you would want to send into mediation versus which disputes, you would conventionally want to keep those parked for litigation or arbitration?
So I think it's both a strategic and practical decision. I think the first question that you ask is whether you want to burn bridges or budgets. So I guess that's the first question. The legal team will ask themselves, and the legal team will discuss with the business as well. Another thing would be, you need to understand what is the kind of relationship that you have with a particular customer or supplier, whoever you intend to go into dispute with. because there are multiple aspects that need to be kept in mind. Is it a solo project that that particular customer or supplier is servicing? Does it have a global impact? Do they are they in relationship with us in multiple projects? What's the kind of impact other projects would have if I go into dispute here? What are the crucial stages of the other projects, and how they are lined up in terms of when this dispute would end? So there are multiple such factors that you have to keep in mind. Another thing would be to also understand what is the business priority at that particular moment. Are we looking at immediate cash flow, or we can wait? So that's an important consideration as well. Then you also need to understand, where does the gap really lie? I think in mediation terms, typically what we call it is the zone of possible agreement. So you need to be able to understand what are the facts truly buried under all of that technical jargon. Last would be that timing plays a very, very crucial role. Sometimes, yes, it's important for you to escalate and move towards mediation immediately, even when you think that the matter may be a little premature. Sometimes I also feel that it is something that you need to wait for, and maybe possibly even go into arbitration and look at the right time for it. Because all said and done, even if it's not a part of the contract, the parties can look into mediation at any time as long as they want to, right? So the timing is also very crucial. So I think all in all, a mix of all these factors is how you get your answer.
Thanks, Mehak. Yeah, I would agree. I think it's not such a straightforward decision at any point. In fact, a lot goes into, deciding when you should send, and if at all you should send a dispute to mediation, or really you should go in through the arbitration immediately and have it resolved. So, yeah, then I think now that we've heard you on exactly why mediation matters, and also what thought goes into sending a matter to mediation, Prashant, we would want to hear from you on, since you are an in-house counsel with a company that deals with a lot of retail consumers, and you have sort of adopted ODR as a mechanism for dispute resolution. So in your opinion, how easy or hard has it been to adopt mediation into resolving disputes with retail consumers?
Thanks, Vartika, for putting up this question. So before I, start, I would just like to give a small clarification that whatever I'm gonna express as my views are gonna be limited to my only, as per my experience and my understanding to the situation, and nowhere it, adopts my says about my company's policies, everything. So coming back to the, question which you have put. So I think coming from a life insurance sector, the experience has been, it looks promising, to be honest, but it comes with its own challenge and its own complexities. First, considering that life insurance sector or the insurance sector as an overall, it's a very customer centric sector. The mediation fits really well within that atmosphere. But it allows the customers to resolve their disputes in a more, in a very quick manner, less time consuming, and more, simplified way. uh, at the same time, from if you see from a litigation, it takes its own course, its own time and everything. So from that perspective, we have experienced, we have tried doing ODRs, we have tried coming up with certain new ideas into the system. And what we have seen is that normally the customers are, willing to take up mediation. So in certain court, the people are willing to take up mediation, but in certain court, people do not trust that process as much as they want to actually do. Specifically, when you see consumers coming from tier 2 or tier 3 cities, or even more remote villages also, where insurance policies are being sold, whenever there's a dispute, they prefer to put their faith into the courts rather than going for a outside dispute resolution, or coming in direct contact with the companies to resolve their disputes from that perspective. So that's one challenge which I definitely see. But what we have also observed and experienced is that whenever a customer comes into an dispute resolution, specifically in a mediation setup, so they are more than we are able to actually close more disputes rather than if we wait through the standard process of going through the courts and everything. I think that we have been able to consider resolve much more disputes than what we could have achieved from that perspective.
Right. So, Prashant, what I hear from you is that mediation has proved to be quite an effective mechanism for resolving disputes, especially in your industry
Certainly.
specifically. Yeah, yeah, that's great to hear. Shruti, coming to you now. So, a resounding theme that we've had, at least in these initial set of questions, is that, mediation is really about burning bridges or making a decision between burning bridges or burning your budget. And also the idea that, time is money, and therefore the decision you make really has an impact on your entire corporate setup. And also that, mediation has practically proven to be efficient. So, Shruti, having seen mediation possibly as a neutral, what is your feeling towards the realistic ROI of mediation in terms of cost, time, and relationship saving?
Thanks for the question, Swastika, and hi everyone. I think this is one of the most important aspects of mediation. What is the outcome and how does it really impact a business? And now I'm restricting it to my response to commercial mediations because that's what we're talking about here. But as Prashant said, I think I'm completely in sync with what he said. It typically would depend from people to people, companies to companies, disputes to disputes, sectors to sectors, and courts for that matter. Because as of now in India, we are still in a situation where most of the commercial disputes either go in through a contract way, first to mediation, very typically theoretically, and then to an arbitration. If an arbitration is in fact, let's say, an institutional arbitration, it will also utilize the med-arb protocols. If not, and if your arbitration institution does not have a proper med-arb protocol, you would end up not possibly choosing mediation, instead going in for arbitration and settling it on the side without a mediator. So that's the reality we're talking about. At a lot of times when these disputes do go to the courts, and let's take an example of IP dispute, which incidentally was one of my first mediations as a mediator before the Delhi High Court. So it was referred to a mediation center. This was between a startup for an infringement of an IP and a very big venture capital fund. And the startup was using the same logo as the venture capital fund. Now here, as you said, time, cost, and relationship. There was nothing in terms of relationship to save. There was time and cost, and that too for the startup. Because if it gets stuck with these disputes, it will not be able to really move on with its life and do a lot more better work as compared to what it could have. So for the startup, it was to get out of this, to realize that IP really matters, because a lot of times startups don't really understand the importance of IP and how it can really impact your entire business and identity. So in that mediation, I saw how in a very small, it was a small quantum. It was not a very large stake mediation, but I saw how things evolved very quickly within one session and the parties came to terms very easily. But when it comes to high stake arbitrations and high stake mediations, let's say a construction contract where the relationship really matters because the dispute itself, even though ongoing, is in a contract that goes on for years together. So the relationship there would really matter. At times in these sectors, you do not have a lot of vendors. You also do not have a lot of choices. So that's where relationship, time, and cost all come in together to play a very important role and ensure that the time in terms of dispute resolution, costs in terms of both parties saving their costs, not just in terms of investment and legal budgets, but also other costs that would be impacted if the project is stalled because of this dispute being ongoing. And relationship, of course, because if we've also seen a lot more of PSU disputes coming in mediation because of the last year's policy change that has started coming in. In PSU disputes as well, many players are repeat players in the market where these issues come up very often, and relationships do matter a lot more as compared to the time and costs when it comes to repeat players coming in.
Thanks, Shruti. That was we've had now a practical insight of, what you see as a mediator and what really goes on in a party's mind while they're going through a mediation process. Uh, so now that we've spoken about some of the positives of mediation, let's focus on exactly what are the barriers that are preventing its adoption more in a more widespread manner, at least in India. So okay, there's a question in the chat box. I believe we can take that up at the end if that is fine. Sorry, as I was saying, turning now to our barriers to the adoption of mediation. Mehak, in your mediation experience, what specifically are corporate behaviors or possibly strategies at the end of the legal team that could potentially derail a good faith mediation?
So I think one is that when parties come in unprepared, which happens very often because I don't think they yet completely appreciate the advantages of mediation. So they tend to just walk in completely unprepared. One is that. Two, also what happens is that the parties that come in representing the companies are not necessarily the ones who have the right authority to be able to sign off on finally the agreement that you reach, which happens a lot in the government customers that we have. Because you end up saying that yes, we're the final authority, but the moment you decide to sign off on something, they'll say that we need to go to the board for approval, and the board approval is, oh, we're going to get it, there's no problem at all, and the board ends up actually tweaking your settlement. So that leaves a very sour experience, and also a lot of waste of time, cost, efficiency, everything. Another would be that I think lawyers are still, I do appreciate I'm a lawyer, but because I'm an in-house lawyer, I think the mindset may be slightly different. So I think lawyers can end up using it as a bit of a fishing expedition, as an informal tool to be able to gather whatever information they can. Another would be the parties being able to understand the kind of mediator that they need to have. All said and done, if you're not going to be referred to an institute or a Delhi High Court or whatever, and it's private mediation, you need to be able to appreciate the kind of mediator you actually need. You do not need anyone exceptionally technical. You do not need anyone that is a retired judge. You need someone who has domain knowledge, not domain experience, especially when I'm talking of construction mediations, because we have highly technical disputes. And if you inundate that one technical dispute with more technical experts and legal jargon and technical jargon, it's all over the place. The idea is to humanize the conflict, and and unravel all the legal jargons to be able to actually come to the core facts. That's what's really going to help you. And from that perspective, the corporates need to understand the kind of mediator you would really need. This was something that one example would be, again, I have an IP one in mind. Like Shruti was mentioning one, that this is not my personal experience, it's a colleague. There were two companies that were involved in an IP dispute, again, the same trademark and logo and all of that. And the Delhi High Court appointed a lawyer who had IP experience, but he had absolutely no idea how to run the process. Absolutely no idea. He just went in, he says, अच्छा आपका problem क्या है, अच्छा आपका problem क्या है, अच्छा ये जो बोल रहे हैं तो मुझे ठीक ही लग रहा है, आप क्या सोचते हो? There were no private caucuses, there was nothing to it. So it's very important to be able to appreciate all of these things, and the corporates to understand why these things are important. That's the only way you kind of break it down and come to what you need to come to.
Thanks, Mehak. Yeah, I would agree. I mean, the last example that you cited sounds pretty frustrating, where it seems that the mediator was sort of bringing in his own judgment of the dispute or controversy to the table. So that's like adding a layer of, further complication to the problem already at hand. Uh, so now coming to the question, is lack of awareness the real barrier? Prashant, do you think in your experience, uh, is the lack of knowledge and or awareness about mediation and the process, and are there any general misconceptions around mediation which really act as barriers to its adoption?
So I think yes, definitely. Lack of awareness is something. When we see mediation, it generally it appears like people are not aware of it, and that's why it fails. But if you deep dive on the thing, there are a lot of misconceptions, fears, resistance that are coming around mediations. People are not very comfortable with the idea of moving into a mediation setup with a company. So first is like that, whenever if a customer or a company are like, if you want to go into a mediation, the first thought will come that, yeah, for some reason, we are doing away with our legal rights, or, we might end up looking as a very weak, opponent to the customer or to the parties, involved in the mediation. So that's one very common notion when it comes to, you know initiating the thought process for even thinking about going into the mediation process. That is one. Second, normally when you talk about a consumer, the general strong belief is that, whenever there is any wrongdoing, or if there is any injustice, then that will come from the justice will always come from the court only, and mediation will not help the way they are supposed to, the way the courts can actually help them. That is one other thing which is there. uh, Another point which we have personally felt is that whenever a customer comes into a mediation, we generally feels that I am on a lesser footing in comparison to a company. The company may have some preferential treatment in that one-on-one discussions happening, despite having neutral mediator. So there's a lack of transparency, or probably lack of faith in the system and as well as in the process. Then obviously, another common misconception is around that the mediation awards are not enforceable, though the Mediation Act has taken away that misconception. But still, a lot of people are still not aware about that mediation awards, they still feel they are in the same thought process that they are still not enforceable, and if they agree to something, they may not be able to hold true. The company or the other party may not hold it true or good. Lastly, I think what I will say that it's a cultural thing to be in on fairness and honesty. It's a cultural thing which has been built from a very long period of time, that it has always been the courts which have delivered the justice to people, be it company or be it customers. So mediation has recently taken up some space in that place, and people have started to, as in how they are experiencing, they started to build faith, but on a larger picture it is still lacking that kind of faith or understanding to this process.
Yeah, thanks, Prashant. I think, yeah, we hear you loud and clear. You think that there are misconceptions around, exactly how a mediation would be perceived, and people already believing that a court would be more effective in, resolving your dispute and also probably enforcing an eventual decision that comes out. So, and you also mentioned the misconceptions around the enforceability aspect. So, an enforceability of, say, a mediated settlement. And Shruti, we would love to hear your thoughts on where exactly does India stand on the enforcement of a mediated settlement?
Thanks, Vastika. I think that's a million-dollar question at the core of why mediation, why not does mediation work? See, when we look at any dispute, the end purpose for any pursuing any dispute resolution process is to be able to enforce what you get out of it, right? Now, when we look at mediation, mediated settlement agreements typically should be able to be enforced at a higher pedestal as compared to any other agreement. But thus far, except when we talk about Mediation Act, which is yet to come into enforcement as such, there has not been a particular sanctity which is separately given to mediated settlement agreements. And that has been one of the biggest reasons why mediation culture in India has not evolved as rapidly as it has in other jurisdictions, which have perhaps taken steps to ensure that mediated settlement agreements do come in a little higher in terms of enforcement priority. Now, what does that mean for us when you talk about the present situation? In the present situation, there are different legislations under which mediations are conducted. Now, mediated settlement agreement is not also specifically recognized there. What usually happens in terms of mediations, if they are court-mandated mediations, or if there are voluntary mediations taken under different legislations where courts are involved, these mediated settlement agreements are reported back to the court and they become a part of the consent order or adopted in these judgments. So, in effect, they become judgments of the court and they have the authority of the court in that sense as a decree. So, when they need to be enforced, they need to be enforced as a judgment of a court, as a decree of a court. If you don't conform to it, there will be contempt proceedings that the court can initiate against you, or the other party can go ahead. And that's a protection that either party can get if this is a court mandated mediation or a court regulated mediation to that extent. But in absence of that, there is very little that Indian parties in India can do except enforce it as a regular contract. There are other options as well, but they're not very common. In terms of cross-border enforcement, unfortunately, we are not a part. Even though we have signed, we've not ratified the Singapore Convention, and that's also something that's really stopping us from being a global hub of mediation. A very interesting very interesting matter that I did very recently was enforcement of a foreign liquidation order in India. Now, there were mediations in terms of settlement with the creditors. An Indian public listed company was involved. But unfortunately, that mediated settlement agreement could not be enforced directly in India because of these issues. So again, you had to go to the court, apply, take that settlement agreement, get a signature from everybody, wait for the court's clock to tick so that ultimately within the 6 months, 8 months, whenever the court really signs off, you get your award, you get your judgment to be able to enforce it only in India. So these are different issues that we are facing in terms of enforcement of mediated settlement agreements, not just in commercial contracts, also in insolvency sphere. And these are expected, of course, not in cross-border insolvency or cross-border commercial contract scenario, but purely domestic disputes when the mediation actually comes into effect.
Shruti, thanks for those views. I think, yeah, we hear you that now, even if you do opt for a mediation, say you really have to end up approaching the court and getting their seal of approval. And sometimes that, ends up giving a party which is not so, which has had like a second thought about the entire process to sort of use that as a mechanism to thwart the settlement as well. I think practically we've all faced that problem. So, Ojaswita, now coming to you, since we've all heard about these barriers in the enforcement and also, cultural and hierarchical mindset problems that we face in adopting mediation. Practically speaking, how likely are you to choose India as the jurisdiction to have your disputes mediated? And as Shruti mentioned, like we are all on the path to becoming, at least we envisage India becoming the global hub of mediation. So how far away do you think we are from that goal?
I believe when we are discussing about making India a hub for mediation, we're talking about institutional mediations, we're not talking about court-appointed mediations, right? And I think when it comes to institutional mediations, we are still a long way when it comes to making India a hub. We're still at a nascent stage. The law is still new. I think it's still yet to stand the test of time, and things like enforceability are still yet to be seen. We have had a very mature arbitration scene in India, but even there, enforceability is a question. You get an award, and you can always go and challenge it. So you're always, in a fix if that is really a solid means of trying to settle a case. And then again, like Shruti said, enforceability is a question, even though the new law says that it is, it can be challenged on very limited grounds. There are very few reasons why you can challenge it, like fraud and it was not as something that could be mediated at all, or it's against public policy and things like that. All that said and done, I think Indian lawyers, litigation lawyers, are innovative enough to find a ground to go and question it in court. So that, I think, is a big challenge when we're talking about attracting a foreign, company, or a party that is not based in India to try and come and mediate in India. Because they can find a ground, or they can find a way or jurisdiction to actually go and put it in court, even though it was not supposed to be in court in the first place. In addition to that, very important to think about the mediators themselves. Mehek brought out a very important point. In India right now, anybody can undergo 40 hours of training and become a mediator. And suddenly you are connected with a mediation, institution and things like that. But is that person really trained enough to be a mediator? Is that person really the right person to be running mediations? I believe we still need to come up with a more structured framework on who can be a mediator, and have industry specific mediators who can actually help in mediation, who are trained on mediation. They don't just have experience in that particular area of industry. And that said, I think yes, mediation is a faster process. As per the law, we have to do the mediation in 3 months as opposed to 6 months or 1 year in arbitration. But that said, when you're talking about making India a hub, you're competing with other institutional arbitration or mediation centers. And there you have express processes in 48 hours, 24 hours doing mediation and arbitration. So when you're competing with that and you say that our best is 3 months, I think we still have a long way to go before we can start becoming a hub. But I think that should not even be a goal right now. We have just got a new law. We have just started. I think even if we are able to cater just the Indian industry, Indian markets, it would be a huge step. Obviously, mediation is very successful in family disputes. A lot of it goes, by course into that. Even the Lodha brothers was actually a family dispute. The court referred it into mediation for that reason. So I think if we can really empower, I think I saw somebody in the chat writing that we need to empower mediators. If we can really empower the institutions, if we can really streamline the processes and streamline enforceability within the Indian market, also mediation will become an excellent way of dispute resolution.
Thanks, Ojaswita. The positive note there is really encouraging, I think. And also now that, since you mentioned the Lodha brothers dispute, Mehek, can you shed some light on these recent success stories of mediation in these high-stake commercial disputes? And do you see these as a breakthrough, or, I mean, is it a pattern? Is it a result of, culmination of different, reasons? Or do you think this is a one-off instance and it's not really as successful as we think it is?
Mediated settlements, you mean?
Yes, I mean, mediation succeeding in general, like we've just heard about the Lodha brothers settling their dispute through mediation. So, I mean, do you see this as a occurrence that is a culmination of different reasons and, the push in the right direction, or do you think this is like a standalone successful?
No, I do think it's a push in the right direction. Obviously, we've been, the act came out in 2023. There's been a very good push and advocacy towards mediation. And we are in the right direction. And I would like to give some credit to that for this dispute, the Lodha brothers dispute as well. And we hope for it to become a better pattern. You're seeing that across board. I mean, Switzerland is coming up, trying to come up as a mediator for outer space activities. And you've got, Trump going into mediation for the Paramount case. And so it's happening all over. So you are going to see more and more successful results. I think what is happening is it's getting much more highlighted now. So we're actually thinking of it. I think the last time when I was judging one of the competitions for Mediate Guru, I had said there that, the chairman of George Lim of SIMC, he had resolved a dispute worth $1 billion in 3 days. That is the kind of impact we're looking at. So you cannot attribute it to one-time success. There is some amount of tact involved from a mediator, and you cannot take that away.
Thanks, Mehak. Uh, Prashanta, let's think about innovations that have helped push mediation along. So, as you mentioned, that your company does utilize ODR platforms for mediation. So, how exactly do you think technology and AI are likely to revolutionize the world of mediation?
Yeah, I think nowadays the common line which we most of the time we are hearing is that AI is the future. Even for lawyers also, if you can't learn how to use AI, you you may lose of your job or something. So I think in mediation also AI and technology will certainly play a very crucial part. Especially in a sector like insurance, where there are very high volume of cases or disputes across various geographies, and these are many time sensitive claims or very emotional claims for customers like death claims and everything. So I think by adopting these kind of tech platforms or mediation through online thing, definitely that is gonna help move the needle ahead. ODR platforms have, if we talk specifically about them, because we have personally utilized those services in our organization, I think they have really, simplified the way how mediations, usually go with customers when we are dealing with, specifically, I'll give you a personal example of that. I have actually sitting into this one kind of a dispute of 1 CR, and the customers belong to a district called as Tinsukia, which is a very remote location. But somehow the platform was able to give access over a phone, and we got into a call, we got into some discussion with a lawyer who acted as a mediator for us, and that dispute got resolved probably in a record time of one hour. In 1 hour we were able to resolve and settle a claim amount of 1 CR for a person who's really sitting in a very remote location. That's how basically the power of AI and technology, how they're going to make things accessible for customers. And I think the companies will also have started to put in money and energy into developing their own AI tools, and or if not AI tools in house, they are actually onboarding some legal tech firms specifically for the to promote, or you can say help them resolve these kind of disputes. Because the power of, so what happens is that again, from our perspective only, if you put on, we are trying to train our own AI tool in house, where basis the precedent set in India, specifically what has been our experience with respect to claim settlements, what kind of disputes we are, basis all those kind of inputs, and learning, the AI is able to actually predict that whether the dispute is worth going for a fight in a court, or whether you should go for a settlement. I mean, these kind of things are definitely helping us in a longer term, and you will see these things grow as and when, specifically mediation is around with the Mediation Act and everything. I think the sectoral regulator is also helping us in that person. So I forgot to mention it previously, for IIDI, who's the sectoral regulator for insurance sector. They have, for instance, 1998, that a provision of having an insurance ombudsman. Basically, it's a quasi-judicial body who acts as a mediator or a dispute resolver for between customers and companies, insurance companies. So and they are basically responsible for resolving all the disputes between a policyholder as an insurance company. And they have also started to adopt, initially it was basically that people used to have to come physically, but they have also moved on to technological driven systems. They want the customer to join through their phone, through any computer, or any sort of way they can join virtually, and they're able to solve a lot more cases than what they were doing earlier. So I think that we are moving in the right direction. Technology and AI is the way forward for this also, and this will definitely help boost mediation in this country.
Thanks, Prashant. Actually, I have a follow-up question there. Do you see AI acting as a mediator, possibly, sitting as a neutral and resolving a dispute?
uh, Swastika, I think I don't agree with that actually, to be in all fairness. Like, I don't agree with the point also that AI can also be a lawyer. you have to have that human touch involved in this. The way the contracts of insurance or any other contract, from if you see the intricacies, you cannot simply just direct an AI person to tell them, "Okay, sir, this is what is written in the contract, and you please do it as per your own judgment." There has to be some level of human involvement there, and somebody who has to certain calls can be taken, because for AI you can simply tell them, he can tell you what is right and what is wrong, but he may not be able to tweak it as per the requirement of that situation. And that's where the human lawyers are required. And I think AI is still far away from that situation where they can get into become a mediator for a customer.
Yeah, Prashant, I do agree. The human touch would be extremely essential. But I don't know, possibly I could learn to mimic that as well in the future. But now we turn to some other questions of how do we innovate and break through to adopt mediation more widely. And one of the points we did discuss is that, inherently some corporates might have some hesitancy in adopting mediation. So, just with how, in your practical experience, do you think that mediation can be adopted right from the go from the boardroom to the mediation room? That is, encouraging executive buy-ins for mediation. And do you think there are some good examples that you can give us on mediation getting adopted as a top-down approach rather than just coming from the legal team?
Absolutely. I think there's definitely a good case. If we can show to the business and the management that, firstly, there's cost saving involved, there's time saving involved, and secondly, there is a surety of the outcome, some level of surety of the outcome, or how it will be handled. I think those really help. Those are the factors that really help in, convincing management in going for some kind of dispute resolution. If we talk in terms of, examples in terms of, say, the Lodha brothers, it was a 5,000 crore case, and it was resolved in barely 3 months. So the cost saving was linked to the time saved. So if the same case had gone on for 6 months or a year, automatically the amount of money that would have been spent on it would be a lot higher, right? But if you look at the people involved in the case, you had everybody from Mr. Khambata to a Dwarkadas to a Kapil Sibal and a Mukul Rohtgi. You had all these law firms, Veritas and Karanjwala and Rashmikant and all. They're not cheap law firms. So if you had those law firms engaged and those lawyers and seniors engaged for multiple months and years, you automatically would end up spending a lot more. So it makes a good case for going in for mediation. But again, it is more court-appointed, what you call mediation when it comes to Indian case studies. So a good case study to look at would be the one that Mehak just mentioned. That was the $1 billion dispute resolution that the SIMC did. That was a dispute basically, I think, between Fuel Energy and POSCO. And I think there were some 5 ICC arbitrations that were running parallelly across London, Seoul, and Singapore. And right now I am doing an ICC arbitration, and believe you me, it's not cheap at all. So if you have those many cases going on, it makes a lot of sense to go in for a mediation sort of a procedure and to have that completed in 3.5 days. I think that is a massive success story to show to any management or board of directors and say that, this is definitely a better way to resolve a case. And I think as more and more such cases keep coming up, people would realize the importance of it. Right now, the boilerplate template clauses that we have for arbitration in our contracts, I think would start having something to do with mediation as well, if these kind of cases keep growing.
Thanks, Ojaswita. So as Ojaswita was mentioning that, we are looking to have more of mediation included in these smaller plate arbitration clauses. So Shruti, from the point of strategy, do you think having these hybrid med-arb clauses would make mediation more palatable both to corporates as well as other stakeholders involved?
Yes and no. I think I don't think MEDAP clauses are clauses which are new to complex contracts. In larger disputes, and because we are talking about large disputes like 5,000 crores, these contracts would typically have a negotiation, an amicable dispute resolution, then mediation, and then arbitration. And then, of course, there'll be carve-outs, different laws applicable if it's a cross-border jurisdiction dispute. So these clauses already exist. And if you have chosen an institution to really go forward with your dispute resolution, then typically these institutions also have mediation rules and arbitration rules. And these arbitration rules and mediation rules go somewhat provide a segue in terms of if you have in fact started with an arbitration after a failed mediation, there are possibilities for the parties to go back to mediation at any point during that arbitration, save costs, divert those amount of fee that has already been paid to the institution towards mediation under the mediation rules. So med-arb provisions in these institutional rules are already provided for. A lot of times, in my experience, what I've seen is, and we'll take an example of ICC itself, a very highly contentious arbitration which went on for about 6 years. And this is a dispute between a Spanish company and an Indian company. And during those 6 years, the matter went from arbitration to mediation about 6 times under the ICC rules. Eventually, at the stage of cross-examination, it did get resolved. There was a mediated settlement agreement. Parties did save a lot of cost despite this matter being lingering for a very long time. And that mediated settlement agreement was, in fact, enforced. So this is one of the examples of a successful use of MEDAR protocols again and again, at different stages in different points of arbitration and mediation, of course. But in my experience, what I've seen is if you follow the whole waterfall process of first mediation, then arbitration in complex, large quantum contracts, that does not often work out to resolve the entire dispute. It's very, let's say, 20% chance that it does get resolved. Mediation really works well when the parties have actually seen where they stand, where the merits stand, or what are the timelines involved, when the costs have really come in. In Mehek, Prashant, and Ujasvita are much more aware and sensitized towards mediation, and they have themselves used it to see the advantages. So when we talk about corporate counsels like them, it's easier for us as external counsels to be able to demonstrate the benefits of mediation because they themselves are aware, they act as mediators, they've acted as mediation counsels for their own companies at different point of times. But when it comes to, let's say, 90% of businesses, and Ojasvita, Mehek, Prashant, all have mentioned, there is a lot of difference between knowing what mediation is in terms of what comes in newspapers, uh, and actually understanding what the process really involves, who are the mediators you should really go for. And mediators, mediation institutions are core to how the mediations really function and very, very essential to resolving any dispute. So, and just to take that as an example, I was involved in writing the report and deliberations for insolvency mediation framework.
Shruti, you're
About one
not
year back.
audible.
One of the most important insolvency to be able to do this.
Sorry, I think we lost you for a bit there, but yeah, you're audible now.
Okay, great. I don't know what part did I really miss out, but the core of it was mediators are really important. We need to train mediators. We need to know who are the skilled mediators. And just doing a 40 hours training course may give you the advantage of having access to what mediation really looks like. But being skilled at it, being experienced at it are two very different things. And it's on the parties, the external counsels, the in-house counsels to be able to really drive that point through for success of even meta protocols.
Right. Thanks, Shruti. That was, very practical insight. And okay, now let's come to the point of really looking forward and how do we implement it, make, mediation more successful. At least the implementation of, mediation more successful within our own corporate houses. So Mehek, if say you were to train your internal workforce of about 100 in-house lawyers on how to make mediation successful, what would be your first slide?
I love that question. I think the title is going to be that mediation is not plan B, it is plan A. And a couple of bullet points there that you need to prepare like it's an arbitration, but you need to participate like it's a conversation. You need to walk in with documents, but you need to walk out with dialogue. So I think these are very heavy statements, but they really need to be pondered over. The idea is not to win, but you need to unlock value. And I think the most major point would be, which I always talk to my business about, is be very clear about your MIT, your must haves, your ideally haves, and your trade offs, which typically in the mediation world we talk of as positions and interests. I find it easier for to explain to the business as to what you need to do. That's your, you go in with your must haves. Your mediation is a futile attempt if you don't know what's your must have. So I think, yeah, overall, these 3-4 things are what you walk in with on the first slide.
I think that was really interesting the way you put it. In fact, very, very interesting insight into how you could possibly, go and train people to make mediation more successful. Prashant, coming to you now, once suppose everyone is sensitized to how mediation works and the benefits of mediation, uh, how do you think when you're looking at drafting contracts, executing contracts, do you think, customizing mediation clauses into contracts is more beneficial, or do you generally choose to go with boilerplate clauses? And what do you think would be the pros and cons of each?
I think Swastika, when I take care of when I am drafting my policy contracts, so I need to take care of one big thing, that I am catering to a volume of 2 crore policy holders at that point of time. So having a very customized kind of a mediation clause for every customer will not be possible for me to make. So in that scenario, I for agents or for my intermediaries, for my policyholder, there has to be a very standardized boilerplate clause to me. But there has to be, the essence of it has to be that there has to be clear. The understanding of the clauses should be very clear, and they should be enforceable. That's one thing that we definitely take care of while we are drafting for policyholders or agents or any intermediaries. But when it comes to, bigger players like, strategic partners, or, you have any international player coming for some other kind of a relationship with us, or reinsurers specifically, we do take care, tend to go into a customized uh, kind of a mediation clause, because we understand that the amount of stake, the stake is very high in those kind of situations. We also need to understand what kind of situation we may land up in, what kind of future frictions we may have, and given that understanding and background, we try to have those clauses customized. Because, and again, while drafting those customized clauses also, we need to be very clear that those are very simple, written in a very simple language, unambiguous language, and there should not be any scope of any sort of what we can say, any sort of friction coming in future, so that they may any loose end or any kind of things. So these are very critical these are situations where we trying to uh, while we draft those kind of clauses. But in practical sense, I have not addressed any kind of situation where we have to invoke those mediation clauses, thankfully, as on today. Till date, we have not been into any kind of disputes that way. So I may not be able to, comprehend what will be the pros and cons from that perspective. But definitely what I feel is that, the clauses has to be that way only. We want to understand in what context are you putting up those clauses.
Right. Thanks for that answer, Prashant. I think now that we've heard panelists on what exactly goes on in-house into, promoting mediation more and more. Ojaswita, in your experience, how encouraging have external counsels been in, pushing corporations to go in for mediation, especially when you have these hybrid clauses and, arbitration or litigation is also an option?
In my personal experience, there has not been a lot of external lawyers encouraging for mediation, but I think I believe that this is something that should come from in-house lawyers instead of external lawyers. Because when we are talking about cost saving, when we're talking about it being a faster process, etc., it's definitely the in-house lawyers that is, encouraging, that is, in fact, drafting the contract in the first place, like Prashant just said. So it definitely has to be coming in or driven by in-house lawyers to begin with. And I believe the one of the reasons why it is not being encouraged or has not got as much of a push from external lawyers could also be because, at least in India, we don't have a very strong institution for arbitration. There is no surety as such. And, I think institutional arbitrators and people specializing in mediation are also not as many in number. For an external lawyer to be prescribing mediation, there should be a specialized practice for mediation in law firms, which I don't think is as common right now. And before we expect external lawyers to suggest mediation, I think we have to build our institutions stronger in terms of mediation. In cases where you have, courts that are providing for compulsory mediation, like the Delhi High Court for that matter, there you will find external lawyers encouraging mediation. They would tell you as a matter of course that this is a matter that would go into mediation. But when it comes to commercial disputes, I think at least within India, we have not yet reached that stage. Internationally, of course, it makes a lot of sense. But in my personal experience, I have not had any external lawyers come and suggest mediation. But as an in-house lawyer, I think it is the more logical thing to do. Yeah.
So, Roswitha, I think now,
Swastika,
yeah,
I have one
Shruti.
thing to add here. I think
Sure, sure.
Jasita made a right point about a lot of external counsels not suggesting it or recommending it. And that's true. I mean, a lot of it depends on what the ecosystem is around you. So if you know that I'm not going to get access to good mediator panel, and it may just be a mandatory thing that I have to go through for 30 days, might as well exhaust those 30 days, come back and actually get down to business and resolving my dispute. I would do that. But a lot of times, at least in my experience, I've also trained with SIMC. I'm on their panel. I train mediators with IICA, the 40-hour training we're talking about. So I'm one of those people giving those trainings. Um, what I've seen is, very importantly in my practice, when we do advise clients to go in for mediation, it would be specific to certain disputes. Now, when I talk about a shareholders dispute, there may or may not be a clause in an SHA, or if it's let's assume oppression and mismanagement, which typically does happen, there will be no mediation initially. So a lot of times you are posturing in terms of appearing weak or strong when there is no mandatory mediation clause. If you go in for mediation first, or am I the first person to suggest mediation? But ultimately, the parties at hand, and specifically the general counsels, in-house counsels, know that mediation is a much better option as compared to going in for a full-blown dispute in a lot of at a lot of times, in a lot of places, in a lot of contracts. And even when it comes to international contracts, a lot of times what I've observed is the parties, the counsel, or in fact international law firms, would not want to go in for mediation as the first choice because of that appearance of not coming across as a very strong uh, party with great merits, with a great case. So mediation is still perceived to be a viable solution internationally, or at certain, let's say, like Ujasvita mentioned, Delhi High Court, because of availability of good mediators. It's not the first choice that a lot of parties make in a lot of contracts, specifically when it comes to critical execution contracts or high value contracts, only because it does not make them look strategically stronger.
Absolutely. Completely agree with you. Yep.
Yeah, in fact, I have a practical experience to share in one of our disputes where there was a made-up clause, and we did suggest to the client that they go in for a mediation before they actually start preparing for a full-blown arbitration, the client actually turned around and asked us, do you not have faith in like our case as such? Do you think we have a weak case and we won't be able to succeed in the arbitration? Is that why you're suggesting it? So yeah, in terms of that, I think we have a long way to go. And I think it's really spreading the awareness that can make a change. Uh, but yeah, Shruti, I think now trying to wrap up on how we can, better implement and make mediation more successful. So do you think the government really at this point has its heart in the right place? Do you think, what do you think has been the role of the government in giving a push to promoting mediation? Like you were mentioning, there's the Ministry of Finance circular, which now mandates mediation for PSUs, etc. So where do you think the government stands on that now?
It's a very interesting question because the government does have its intent in the right place. And I think that's also come in one because of escalating costs, not just for us, because government's one of the largest litigator in the country, specifically even when it comes to commercial contracts. And they've seen a lot of those finances can really be put to a better use or redirected into the justice dispensation system if we have alternate resolution mechanisms, specifically mediation, which is quicker, much more easier and less burden on any of these uh, state institutions. One. So government's intent definitely right place. What government has also seen through this data collection exercise, and we spoke about tech and AI, all of them have really guided the government into coming in to see what really works best in terms of reducing costs, time, delay, utilizing the state resources in the best manner possible, which has done in turn led to mediation being given a larger push. Another thing that I've come to understand, and that's my experience from being on the policy side of things when we came to Mediation Act, mediation rules, which will come in soon, and the insolvency mediation reports and the workings of it, is that the government also puts a lot of premium on building the mediation culture and wants to take up the responsibility, like in the West, where the state institutions, for example, in the US, courts themselves made the rules for mediations for each court and they implemented it. They empaneled mediators, they welcomed them to come in. Similarly, Indian government also wants to give a push to build this mediation culture. It's ultimately a chicken and egg situation. You won't have a great mediation culture unless there's a push, and that push itself will only come in when the government tries to build this mediation culture for a healthy environment in terms of mediation to be picked up as a credible commercial contract dispute resolution mechanism. We've always seen that when we talk about mediation, your mind automatically goes to family disputes, uh, and even business family disputes, and not just core business where families are not involved. So that's the diverging trend we see now, specifically when Mediation Act has come in. These different notifications have come in, specifically the Ministry of Finance notification, which has been variedly adopted by different PSUs. That process is still on. The recent litigation assessment, there's a circular again on a notification on what litigation policy should look like. A very incisive 40, 50 pager, where the government has also given a lot more premium to resolving the disputes outside the state justice dispensation system, that is courts. So all of this in sum tells us that the government, for its own disputes, is taking a very hard look on what is a good investment for it. Where can it save costs? Where can it build confidence in terms of doing business in India? India being a credible investment source for foreign investments. And also, improving the domestic dispute resolution system. Because when we look at countries and we talk about these terms as hub of arbitration, hub of mediation, you're looking at these isolated cities in very small jurisdictions where they have actually built their reputation for others to come in. And if we compare apples to oranges, India is a huge country, just like the US. You don't see US as a hub of arbitration or mediation because they themselves have an ecosystem inside where internal disputes themselves are so huge that if you possibly put in your resources to resolve them, you are a hub of arbitration or a mediation yourself, right? You don't technically need cross-border disputes to become a hub of that arbitration or mediation. It's the same it's the same story for India. I mean, we have so many states with different GDPs, state itself, like manufacturing, automobile, tech. If you just concentrate on resolving those disputes to mediation or arbitration, you are a hub of mediation and arbitration already, and people will come in and approach you. So government has been thinking on these lines. When we talk about Make in India, it would be resolved in India very soon, for India, in India, by India.
I would just like to add one more point to this, to what Shruti said. The government, before the Mediation Act also came, the government through the sectoral regulators have also been pushing that way, in that direction actually previously. Like if you see RBI, if you see IIDA, or if you see PFRDA, all of them have some level of regulatory mandate to, have the companies or the regulated entities to incorporate certain level of their internal governance that way only, that disputes can be resolved prior to customer actually moving out into the going to the court or something of that sort. So recently IID is also pushing up for an internal ombudsman, just like what RBI is having from a very long period of time. So these kind of things are also prevalent, and the government is thinking to push it from all sectors actually, in all directions. So one is obviously what Shruti said, but this is also something which has also been going on for a long now.
Thanks, Shruti and Prashant. I think overall this session has been extremely insightful, and what really it made it really refreshing is that we didn't go into the theoretical bits about mediation and how it works, and how we expect it to be a win-win process, but we really heard so many practical insights and real-time success stories that each one of you has really faced. So that's really encouraging, and all of us really get that idea that mediation is working, and of course with more awareness and training, it is likely to become more and more the preferred mechanism for resolving at least certain types of disputes. So I am through with the questions I had, but now we've had a couple of questions put up in the chat box. So I'll just put them out there for any one of you to take up and answer. So one question I see is from Tanima Tiwari. It says, in your experience, have you ever faced a tough call between going ahead with mediation or opting for formal litigation? And she says she's curious as to what kind of real life factors or past cases have shaped the way you made your decision.
I think cost benefit analysis, at least as far as in-house is concerned, that is a very, very crucial tool and almost always works. Because when you talk about the benefits, all your previous history of your disputes and how you've been performing in terms of it, or what is the time that it takes, etc., versus the cost, all of your previous experiences come in there, and that's, I think, the biggest factors for you to decide.
Right. I think participants, if any of you have questions, I think now's a good time where you can unmute yourself and just address the panel directly, or alternately, if you prefer putting your question in the chat box, I'm happy to read that out to the panel. Okay, so Shreyas has a question, and it's about how does one end up practicing mediation in corporates, and what would it be the path and the strategy for a student?
Take part in the international and the national competitions that you have in mediation. Now lots of them have really come up. Be active about mediation advocacy. And I think you're already started studying mediation as well as a subject, right? So I think those are the right paths to go on. Maybe we have other internships in time. I know it's not available right now, but you'll be able to shadow mediators in some way, in some sort of programs. That would also help, I guess.
Are there any other questions?
Hi, Swastika. Nice to see Shruti and Mehak again after a long time. I've been a part of some conferences there in Hyderabad. My question is not exactly a question, there is a problem. What happens in courtrooms? Judges sometimes don't encourage mediation. And what they do mediation themselves in an open court. So how will it work in future? Whatever we are discussing here about mediation, encouraging, even the judges do not encouraging it. They do it themselves in open courtroom. What is your saying on this?
See, they need to, that is why a lot of weightage is being given to training in mediation. And especially for judges, what they need to understand is a lot of unlearning will go in before you actually start learning about mediation. It's, I think, the most relevant exam, because a lot of the times the judges come with this mindset that I know how to resolve a dispute, I've done it all my life, right? But it's like, if you know how to drive a car, doesn't mean that you can drive a F1 car. There is a difference, right? So you will have to unlearn. So it's unfortunate if that's what judges are doing. I did not know about that. But yes, I think training is a very major tool that needs to come in, which has already started. A lot of the states are training their entire judiciary on mediation and even on arbitration. So I think the change is going to be slow and steady, but it's going to come about.
One more thing, can I ask?
If I can add to what
Yeah,
Mandy
please.
said, and then Anushka, you can probably ask your second question. So I think right now the case that you described is a very ad hoc approach to mediation. It's not an institutionalized way of doing mediation, and that's why this is happening. And if you look at the act itself, confidentiality is at the core of it. You don't need to register a mediation award. Just like arbitration, mediation is a confidential process, and it is between the parties and the mediator. So there should not be this, way of doing it in an open court, because that's not really how it's supposed to be. But then again, it's not an institutionalized way of doing mediation. It is a very ad hoc way in which the judge feels that, we can mediate in open court, but that's not really mediation as per the term or the way that, we look at it in institutions, right?
I just had one point to add, and this is perhaps a very flip side view. Interestingly, I was speaking to one of the mediators who's a retired High Court judge. He's one of the most, uh, engaged mediator in terms of commercial disputes. And he told me how the parties approach him, because it's the lack of awareness that's the point I'm trying to highlight. The parties come to him and they say, "Sir, we'll do whatever you say. You don't need to talk to either of us. You write a judgment or an award." In a mediation, one, you really are facilitating a dispute resolution process. But that retired, he himself said it. Just because I'm a retired judge, they place me in a position where they want me to write an award for them in a mediation. So this works both ways. It's not just the judges and sitting judges who need the training or mediators who need the training. When we talk about mediation culture, everybody, including the parties, need to be aware of what they're getting into. If you're going into a mediation expecting a judgment on an award, or arguments from both sides with the counsel present, that's not how it works. So we're talking about the process in total being very fair, transparent, accessible to every single litigant who enters the step of the court.
Right. One more thing I would like to add. Like I'm a family mediation expert here. So what happens sometimes, like if the parties are totally ready, I mean, for settlement and final settlement, they are asking for, because they don't want to spend more time. Like they say, we need immediate and full and final settlement the same day. So kindly just make it final today, and we'll go happily. So what happens here in courts? Court usually say that send them for 2 months, minimum 2 months to live together. Thereafter, after 2 months, take their some reports. I mean, there is any kind of dispute in between and all. Then make a final settlement. What I think that, don't you isn't it like we are lingering it more and more? I mean, if the parties are ready for the final settlement, still courts are saying no, 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 make it pending for more 2 months and all. And one more thing, what I would like to add, that I mean, from all the mediators and arbitrators here, don't you think that mediator need more power in this regard?
I think it would be a bit of a contradiction if you're trying to give the mediator more power, because ultimately it is supposed to be a voluntary process. The mediator is only supposed to be a facilitator. So giving a mediator more power, I don't know how. I feel like it may cross backfire. But yeah, what I would say is that you have a lot of countries where you have, not to say mandatory mediation, but what you have is an opt-in, right? So you have to show up on the first session or the first three sessions. You have to show up, otherwise you could be penalized. And thereafter, of course, parties can take the decision to walk away if they don't want to continue. Something like that, yes. But giving, I'd love to understand what you mean when you say giving a mediator more power.
It's about like if we'll be given a power of deciding it immediately on the same day for the final settlement, and parties agree, because everything is being done with their consent. So we are not pushing them for the immediate settlement. If the parties agree and they are saying that we are ready for the final settlement, why courts are lingering it on, just because they are saying just do it for 2 more months and thereafter submit a report, then we will allow you to do final settlement. That
So this
on
this
that
is
power.
court designated mediation, where they're asking you to.
Yes, yes.
Yeah, well, that because I don't do family disputes, so I'd go with you for that as far as that is concerned.
Yeah.
I agree.
I think I'll add here. Actually, I had a fair bit of experience in handling family disputes in the initially of my
Please,
career.
please.
So I think the idea is around the institution of marriage. Actually, they don't want to set any kind of a precedent in the country or in that region, which allows quicker disposal of, quick ending of relationships. Very, making it very easy for people to just come and get it done. I think that's more from a social standpoint, how the country is evolved. Probably that is the mindset behind why the judges keep on pushing it for a longer period of time. That is, I think, otherwise there is no bar specifically if the parties are agreeing to it. And and now if you see recently, I think they have been a provision also that you can actually, for a marriages you can waive off those 6 months period of time also. So I think courts are moving, but gradually. They're not rushing into it to allow people to, it should not be a free flow kind of a thing, because it will destabilize the entire social economic system of the country. And I think that's the basic rationale around this.
Also, I think when it comes to mediation, making it compulsory sort of defeats the purpose unless the parties are also in it, right? They have a buy-in. So I think compulsory mediation is something that can be questioned. That's very common in family matters, like you said. But I was talking to a retired judge who does refer matters to mediation, and the resounding success of resolution of disputes after mediation is, I think, a very strong ground for them to stick to this compulsory mediation. If you look at the family matters, like 80-90% of the cases get resolved in mediation, which I think is such an encouraging reason why we would continue to have this compulsory mediation. But I do agree there are mature parties. There could be a situation where both parties have already agreed, and there's no reason to go in for an extended period. But then, yeah, I think that also again goes to the same point that you raised earlier, the awareness, the level of understanding, and how much is the judge really ready to listen to the parties in each case. Yeah.
Thank you. Sunday went well with all of you.
I even have one question if I can ask.
Yeah, Ria, sure. Go ahead.
Yeah, okay. Firstly, good evening and thank you for the wonderful session. I heard each and every bit of it and I got a lot of knowledge from it. I am a law student, so I have a law student centric question to ask. Like, I wanted to know, like, how we as students can incorporate mediation skills into everyday communication or conflict resolution. Like, how can we improve that skill or build that skill apart from participating in the competitions?
Okay, Ria, I think since no one else is answering that, I'm going to take a shot at it. Um, I think at your stage, the one thing that you need to be able to practice again and again is the process. Yes, of course, it's a part of the competitions which would really help. But I truly believe mediation is a skill. It's a personality development exercise which comes in handy in every sphere of life, including your family, including fights with your siblings, all of it. So as a first step, maybe pick up a book, go through the process, and a couple of the tacts that you need, and start consciously exercising them in your daily life. It's almost like being a life coach. So I think a book would really help for starters. I think there are a lot of them out there that give a lot of simple concepts or explain them in a very simple manner. So I think that could be a starter.
Definitely. I'm already reading one book called Mediation Simplified. So I
Okay.
I think it will help. And thank you so much for that. I'll definitely try.
I can move to the next question.
Yes, I think someone had unmuted themselves. Otherwise, there's actually a question in the chat which can be quite interesting. So the question is from Parth, and he asks, do you think that people stay away from mediation mainly because they do not know enough about it? Or is it also because some lawyers hold back because they feel that it might cut into their role? So, Shruti, do you have any comments on that?
It's a very common thought, and it's very rightly put into a question here. One is, I think a lot of people don't know about it, including lawyers, and we've really spoken about it, how mediation is the buzzword these days, and everybody wants to know what mediation is, do what mediation looks like, but at the core of it, there's a lack of training and understanding on that skill development, like Mehak just mentioned. So for that purpose, I think one, there has to be a larger training of lawyers, litigants, everybody involved in what mediation is. Mediation is not just for lawyers and judges and dispute resolution professionals. Mediation is for everybody. And I think I would give an example of the US, where mediation is taught to eighth graders in a lot of states for them to understand how to resolve conflicts and not just disputes at a very young stage. So the whole purpose of that is to ensure that the society as a whole is a lot more of conflict resolution society as compared to dispute resolution only for lawyers. That's one part of it. We've in our culture have already had it, but perhaps because of different reasons that has not come up. We are a very diverse country with different languages, different people, different regional attributes. So we're also trying to develop that now. When it comes to lawyers holding back information on mediation, when it comes to it may cut their role, I think that is a yes and a no. A lot of times you would see that lawyers do recommend mediation in disputes where they think that mediation may work out. Parties may choose or not choose to go for it. The lawyer's role in mediation is not just limited when we talk about commercial disputes, because commercial disputes do require lawyers to actively advise their clients on merits or the lack thereof of the case itself. Uh, and like Mehek and Ujasvita, Prashant all mentioned, mediation is not something that you go unprepared in. You actually do read your case when it comes to commercial disputes. You understand where your merits stand and then go in for mediation with a lot more preparation as compared to what is typically understood. It's not a coffee table conversation. So I don't think lawyers who do know mediation or parties who do understand what mediation is all about shy away from going in for mediation or recommending it, but it's the lack of understanding of what mediation is that may hold it back. And to be fair, a lot of times I, as a lawyer, when I'm advising my clients for mediation, would not want to go into that room because at times, in terms of positioning or posturing, lawyers may not be really required inside the mediation room from for a lot of reasons, not just positioning our perspective. One of the parties may refuse to have lawyers in the present in the mediation just because they think it may become a lot more adversarial. So lawyers themselves hold back. It's the client's prerogatives to take them inside or not. Advising, yes, perhaps not being actively a part of it, a lot many times, even in family disputes. Uh, I don't have a lot of experience in it, but I understand a lot of times lawyers do not go inside the mediation rooms. The mediators themselves require the parties to come in without a lawyer unless they would want a lawyer present for certain purposes.
Thank
I
you
think
very
I
much.
would like to just add on this,
Yes,
a
please,
small
please.
point actually. So, while Shruti and everybody has talked about, institutional mediation and disputes, I think from a retail customer standpoint, one point is very much there is that it's not just about lack of knowledge, it's about lack of trust as well. A customer, having a dispute with a company or a person, he's already burnt bridges certain way. He's already been, at a loss in certain point of time, and is having uh, trust issues with that person or that institution, and that is why he's not fully into it, because he may again suffer some kind of a loss. That's basic mentality which is there. I think it will gradually start to evolve with as and when the Mediation Act and every other development keeps on taking place with its own pace. I think it will start evolving, but yes, this a very big reason is the lack of trust as well. It's not just merely not having knowledge about the process, but yes.
Uh, Good evening, everyone. If I may ask a question.
Yeah, I think we're just running out of time. So if it can be quick, and maybe we'll make this the last question.
Okay, okay. So, my question is, given that mediation as a subject is not comprehensively taught in most of the law schools, and arbitration as a subject is often limited to just a single semester or 1 year max. So, how do you suggest law students and young professionals develop a balanced and practical understanding of both mechanisms? Like, if they are focusing more on IPC, CRPC, and this traditional litigation concepts. So, how would you recommend law students proactively prepare themselves for the growing field of ADR in this era?
I'm going to let someone else take this.
Okay, I'll give it a shot and then I will hand it over to you, Shruti, for you to add insights. I think to begin with, I believe even if you want to specialize in mediation, it's very important to have a very good basic understanding of litigation. So CPC, CRPC are not exclusive even if you want to specialize only in mediation. I believe to be a good mediator, you need to understand how disputes work, how a court will look at it, and how you need to really resolve the matters later on if the mediation fails. That said, I think it's already covered. Meg also mentioned, about reading books, etc. But also try to get some kind of practical aspects of it. Try to see whatever mediation cases are there in public domain. A lot of it is confidential, but there are some cases that are out in the public domain where you can really understand, where you can really, get to know. I think to become a mediator, you need to be at least a graduate. So you need to complete your graduation and then you can get a formal training on mediation and how to become a mediator. But if you are somebody who has already done a graduation and is then doing LLB, you could probably do it parallelly along with your course. But I think to be a good mediator, you need to have a very good grasp and understanding on how disputes work, how parties work, how people behave in disputes as well. It's not just like I think we began the discussion with, it's not just dispute resolution, it's also maintaining relationships and things like that. So it's not just, this is what the law says, this is the clause, this is how, therefore, we are going to interpret it. So you get this and you get that. That's not how mediation works. So I think that aspect or that understanding of mediation you will develop only once you start looking at practical applications of mediation and not just, look at it from a course that you can develop and you can become a good mediator. Over to you, Shruti.
Absolutely. I think I just have 2 points to add to what Jasvita said. One is that
I believe some technical error at
legal process or a very substantive legal training. Oh, sorry, I think I froze. Am I audible now?
Yes, you're audible.
It's like, so mediation is not just a substantive, subject like Ujasvita mentioned. It's perhaps something which is a matter of process. And mediation is a business solutions for legal problems. It's not a legal solution for a legal problem like arbitration and traditional litigation. So that's a distinction you need to keep in mind. As you read more, as you understand more on the process, on the substantive issues, including, let's say, if it's a tech mediation you're going into, you'd probably be better placed as compared to someone like me who does not really have much experience in family disputes. So, in that sense, that will also assist you over a period of time. So, Mehek's suggestion on reading more, or Jasita's suggestion on really concentrating on what you're reading at hand, supplementing it with internships later on, would be the best course forward.
Okay. I think since we've already exceeded our time, so maybe we'll close this session now. Thank you all so much. I think it's been, I hope all the participants have had as much fun as I've had, moderating this session. And I would like to thank each and every one of the panelists really for such an insightful discussion. Kanika, over to you for any concluding remarks.
Thank you so much, Kartika. And with that insightful final point, we unfortunately reached the end of our scheduled time, today's panel discussion, Mediation Inside Out, Barriers, Breakthrough, Adoption, and Corporate World. What an illuminating session it has been. On behalf of Mediate Guru and everyone who joined us today, I'd like to extend our sincere gratitude. First, a huge thank you to our brilliant moderator, Swastika Chakravarti. Swastika, you were masterfully guided the conversation, ensuring we explored the topic's many facets with depth and clarity. Thank you for keeping us engaged and on track. And our deepest appreciations goes to the esteemed panelists, Ms. Mehak Oberoi, Ojasvita Srivastava, Prashant Singh, and Shruti Kanijo. Thank you all for so generously sharing your valuable time, expertise, and candid insights drawn from your diverse experience within the corporate world. Your perspective on the real life adoption, the genuine barriers, and the exciting breakthroughs in mediation have been incredibly enlightening. We hope this discussion have provided